And that's probably as unreasonable as the $25 million. But I understand the court's concerns. I understand every court's concern. I understand the statutory language of bail. But generally, bail is something that is presumed. There's very rare circumstances under which you say no bail. Thank you, Your Honor.
Thank you, sir.
Yes, sir.
The bail schedule in this case is $3,335,000. I'll hear from the people.
Thank you, just briefly. I disagree with probably 95% of what Mr. Fletcher said, but I'm not going to waste everyone's time. I agree that there is a time and a place to litigate the facts of the crime at the preliminary hearing. That's not bail. We are simply here to discuss bail. The factors are enumerated, and that's what I put in my motion. The primary consideration this judge has to consider is protection of the public. This defendant, when I wrote this, I was appalled that all these crimes have taken place, and he basically is above the law. And this defendant has been on probation, and it didn't work. He was on parole, it did not work. He's been convicted of felonies in California, Nevada, federal court, nothing worked. He then, in 2014, was charged with a robbery, and it's a life sentence. He was given bail, this fact that counsel didn't even mention, and not only did he comply with the terms of the bail, he escalated his behavior and committed murder. So what do we do with him? Because how do we ensure that he's not going to get out and kill someone else, that he's not going to get out and threaten these witnesses, as he's done for 30 years, that he's not going to get out and extort more people to get more money to pay for his defense? How do we know that he will follow the laws? If you look at his past behavior, which the court is mandated to do by the code, his past behavior has given us a very clear message. 30 years of past behavior. I will not follow the law. I do not care about human rights. I will be a woman. I will be a man. I don't care. I will do whatever I want. I will use a handgun. I will bring 8 to 9 people and beat someone in their own driveway. Because that's the kind of person this is. So this court has to set bail high enough to make sure he'll follow the law. And to be honest, I don't think any bail is enough for him. But $25 million, if he can come up with that kind of bail, at least that may be financial incentive enough to stop this behavior. And if it isn't, so be it. But we have to do something. The code is clear. Public policy, the protection of the public is the primary consideration. And I put this all in writing, so I'm not going to belabor the point. But based on that, that's why we're asking for the $25 million. Thank you.
Judge, she's appalled that she didn't file a single charge.
I understand.
And you know, the personal attacks on him get to to really the heart of this matter. They don't like him. They believe the hype. They believe that it's like Empire again. They believe that this guy's out here running all these criminal enterprises. And I'll point out, I've been in this.
I'm sorry, Mr.
Sir.
I'm not interrupting you.
Yes, sir. I apologize.
If there's any more outbursts, any more mumbling, I'm going to ask the deputies to remove that person. This ain't the streets. My apologies.
No apologies necessary. That she doesn't like him, and she says, I don't think he should have bail. Really? That's not the standard. We're supposed to be sitting here meting out justice blindly. She has intentionally and identified this gentleman as a person for her wrath. I have been on this floor trying cases with the heads of the Mexican mafia or the heads of the Black Guerrilla family. You know what they all had in common? Bail. Bail. He talks about... Thank you, Professor. Could you please, if you're going to, the schedule amount is
$3,335,000.
I'd ask you to release follow the schedule.
Thank you.
Thank you, Judge.
All right, I am bound by the dictates of Penal Code Section 1270.1 and 1269C. First thing I have to consider is the maximum sentence that the defendant may face, assuming that all charges are true. And it's at least multiple life terms, and just for count 1, the murder, with nothing else, the minimum term would be 75 years. So that would be 75 to life just on count 1. I have to consider the danger to other persons if the defendant's released, and again, assuming that the charges are true, and looking at the People's Memorandum, there was numerous incidents outlined in this memorandum, the potential of harm to others, and the continued serious crime potential was great. The defendant appeared to have made numerous threats to others and engaged in multiple instances of violent conduct. He has ties to states outside of California, for example, Nevada, where apparently he has fled, according to the affidavit filed by the investigating officer in this matter when he sought no bail from Judge Bramlin. The defendant has a great potential to flee, and apparently has so in the past. In this court's opinion, $25 million is reasonable, and it is so set. There's a second issue that I must get to, and there's people asked for a what is known as a 1275.1 hold. That's pursuant to section 1275.1, the defendant not be released unless the defendant shows by preponderance of the evidence that any part of the consideration is not feloniously obtained. I've read the people's position on this. However, this is not given under oath. And at this time, if you're willing to back this up, I'm going to ask that you be placed under oath. Ms. Barnes, place the attorney under oath, please.
Do you want me to stand or will you?
It's up to the clerk.
That's fine. You do solemnly state that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do, thank you.
Please state your name.
Cynthia Barnes.
Ms. Barnes, I've read this memorandum to the best of your knowledge under penalty of perjury. Are you agreeing that this is true and correct?
Yes.
Very well.
May I cross-examine her, Your Honor?
You may cross-examine within the scope of what I stated.
Oh, thank you, Judge. No, thank you.
Thank you. I do find good cause pursuant to penal section 1275.1 that the defendant is not to be released unless he shows by preponderance of the evidence that no part of any consideration for the bail was feloniously obtained. This matter is here as day 0 of 30 for preliminary hearing.
Your Honor, may I ask for clarification? When Mr. Knight bails out with a bonded bails person, would that be sufficient?
The consideration that is set up for the bond must be shown to be not feloniously obtained.
I understand that, but Mr. Knight, obviously, I apologize.
It's our very informal here. If you want to sit, sit. It's up to you.
It doesn't matter. About now. Those orders always give me concern, because literally if I choose to go sign a bail for my client, then the people's argument would be it was feloniously obtained, because they're arguing that anyone associated with Mr. Knight, it would be felonious. They've made these allegations again, and I understand the court previous ruling. I mean, I guess he's John Gotti. My client's John Gotti. He has a bigger bail than John Gotti. But if Floyd Mayweather walks in and bonds my client out, are they going to be then subjected to Mr. Mayweather's going to have to sit down and be accused of, I don't know, running a criminal empire as well?
I don't think so. Again, you're asking me to make a ruling in advance, which I generally do not do. You would have to show that the source of funds has not been feloniously obtained. That's all I can say. And
so what they're saying is that regardless, anyone who bails them out will be subjected to investigation by the district attorney's office and the sheriff's department for something that's never done to anybody else.
I don't know if that's what they're saying.
Okay, y'all.
It's 0:30 for preliminary hearing. I'm going to be engaged in trial, but that doesn't make any difference. I'd be glad to recess the trial for the preliminary hearing. Next week is not good. I'll be teaching, actually I'm teaching homicide and death penalty to other judges.
Maybe on April 3rd?
Is April 3rd acceptable to people?
Well, Your Honor, it's 0:30, so...
It is 0:30.
Yeah. And we did a specific waiver on the record, and we might need to take a minute order. I can't remember if the calendar days or court days. It's normally court days.
It's 0:30 calendar days.
Mr. Knight did not agree to any continuance.
The counsel did.
Mr. Knight's counsel arguably wasn't his counsel at the time. He had been fired prior to that. And this is a personal right. And you know, they jump up and down and say he can't get out. And then when we want to have a hearing to prove he's innocent, now they want to put it off for how long?
Well, I don't know. I'm holding that this is 0:30 calendar days.
He did a time waiver in court.
I understand. I've read the minutes.
Okay. So...
He also took a 60-day time waiver. I'm aware of that as well.
Thank you. So I would suggest the week of April 13th. Any day that week should be fine with us.
The 13th is 24 of 30.
Any day that week is fine, maybe the 16th?
I'd suggest the 16th, Ms. Barnes, only because I have another proceeding I'm in. If the 16th is okay with the court, it would help. But if it has to be the 13th, I will try to make it.
Judge, I don't think those are fair considerations. These people are in jail. These people get phones. These people can have Benny. This is absurd. I'm not absurd. If that argument is, well, what's convenient for them, he's entitled to a speedy preliminary hearing
That's
as
correct.
well.
So that's 30 days of today. Any day the week of the 13th is fine with me.
13.
All right, matter is set for preliminary hearing, April 13, 2015, 8:30 a.m. This department, that is being a 24:30. Let me inquire, we're not quite done yet. Just a general time estimate, and council knows things go here fast, of how long this preliminary hearing is going to last.
I think the people's evidence will probably be 3 to 4 hours. But that doesn't take...
Is a day sufficient?
Yes. Can we inquire, because they're going to have to grant immunity, and I would ask for, and I'm asking this court to order, that when they grant or any discussions regarding immunity be immediately turned over to the defense for purposes of preparing for the preliminary hearing. Because Mr. Sloan cannot take that stand without, he can
I
do
understand
whatever.
what you're saying. The only thing I can grant is discovery pursuant to section 1054.1 A through F, and that's what I'm doing.
Yes, sir, but I'd also ask the court, I think this falls under Brady material because of the exculpatory leading to impeachment evidence, and if their people, their star witness is asking or asked for immunity, we're entitled to know because that's an admission.
And if it's under Brady versus Maryland, as you state, that is a obligation by the people.
Yes, sir.
That I do not get involved in, and you have your remedies if they do not follow through. If I can see counsel's sidebar, that's something I do not want to discuss in open court. Anything else we need to discuss?
No, Your Honor, thank you.
Thank you all, counsel.